we've gone over, these are cases involving Mr. Jose Torres. There's several cases involving him of 1, 2, 3, 4, 5. Is it like 6 or 7 cases?
I believe so, Judge. I do believe so.
And what do we have as a total amount of the bond?
Well, I'm trying to calculate it up right now, and I think it's about, they're all at about 50. So that's 1, 2, 3, 4, 200. I believe we're at about 243,000, Judge. And there's 1, 2, 3, 4, 5, 6, 7. Let's see, 1. There's 7 cases, Judge. To be exact.
You say they're all approximately 50,000, so that would be about 350,000. Miss Ritchie, do you have any better estimate on those?
I am trying to look, Judge, but I can't see them all in one spot.
Yeah, so Judge, excuse me, Judge, for clarification, there's the 2019 786 is 50. The 2019 5099 is 50. The 2020 2020 is 50. However, we do have a 2020 1961 that's only 20. And then we do have a 2020 ending in 1967 that's also 20. So please forgive my initial assertion, Judge. 5 of them are 50. 1, 2, 3. 4 of them are 50, and then 2 of them are 20, and then the 2020 ending in 2240 is at 3,000, Judge. So there's
so we're more like about 250,000.
There we go. Yes, sir.
Judge, he has 2 cases that have already been dismissed, I believe. The one ending in 2240 and the one ending in 2020.
Okay, so they've dismissed 2 of them, 2240 and which one?
And the one ending in 2020.
Yeah, those are both the under 1 grams, right?
That's correct, Judge.
Those were the smallest cases.
And very quickly, Judge, we just got him back from getting comped. He came back with a valid competency, and so we haven't had him for a little over a year, Judge. And I don't know if you recall, Your Honor, but this is the individual that I was begging to see if we could do some bench trials on.
Yes.
He's got 3 aggravated cases, Judge, that I think if we do bench trials on him, I that would end favorably for us. I think we could definitely close out the rest of the cases, Judge. Considering that taking away those, then we're looking at.
He's been in jail like over 400 days. About 450 days.
That's correct, Judge.
A lot of that's because he's been in competency court, but now he's back. So we got to figure out a way to try these cases or resolve these cases.
And I can tell you, Judge, without getting rid of those 2 ag assaults, Judge, there's no way we're going to be able to come to a reasonable resolution. I mean, the allegations are sort of pressing on the state to be hardline where they're at. And I do know that I feel favorable in regard to the CW on those cases. So if we could do bench trials on those, Judge, I'd be ready at the court's earliest. And of course, with the permission of the court, man, that would resolve a whole bunch of cases on the docket.
And Judge, we did email Mr. Kanata on this. I don't know if yourself was on it. I do believe maybe Michelle was on it. But she wouldn't have known to then send that to you. But we have made Mr. Kanata aware we are not at this time, we are asserting our right to a jury trial. We will not waive our right to a jury.
Okay, well, that resolves that issue because both the state and the defense have a absolute right to a jury trial. And so
having said that, Judge, I am asking that the court assist us on a bond reduction. I have his mother who would like to come on online to testify that he can live with her. She's the one who retained me, Judge. I don't believe he's a flight risk. But you know,
Well, I'm not going to make his mother come on and say that. I'm sure that she would say that, and I'll take your representation that mother says he can live with her.
and I'm sure with some house monitoring or some intensive bond conditions, Judge, we can ascertain that, you know, that Mr. Torres not be, you know, not be allowed to even be in a position to a place where society would be concerned. He's definitely not a flight risk, and I do believe, Judge, having asserted my position as to those two aggravated charges, you know, I feel quite favorable on those two charges, Judge. And absent those two charges, you know, we're not looking at anything serious on the plate anymore. You know, those two charges are pretty much the bulk of the concern, I'm sure, of the state. I mean, they're all concerning. I mean, I'm not going to mitigate the seriousness of any of them. I mean, they're all felonies. However, we take out those two aggravated charges, Judge, which I feel we can do. You know, I do think that holding him in there, you know, on something where he may already have been time served. I mean, you know, looking at some state jail, third degree, you know, charges. You know, I'd like to see if we can get some help on the bond, Judge. I mean,
All right. Well,
Judge,
let me do this. Yeah, go ahead. Did either of you want to say anything? I'm thinking about taking it under advisement at this moment, but I want to hear what Ms. Vergara or Ms. Ritchie think about the bond.
And just to remind the court, Judge, on this particular case on 5099, the victim is, you know, the defendant is alleged to have gone up to the victim and say, "Te voy a chingar." Now, that translation can vary depending on who you're asking and on what it may mean. And then when he searched, he does have a utility knife on him. Not only that, Your Honor, but I do believe in this particular case, the victim was aware of who the defendant was and therefore could identify him or did identify him at the scene. Now, in the other case, Your Honor, Ms. Lexa, can you help me on that? Is that where the hacksaw was used?
Yes, Your Honor, the 3786, I believe that they were friends. Oh, no, not this case, not the 3786. What's the cause number?
I know I have a lot of notes on both of these cases. What, the 5099, is that the one you were?
I believe so, Judge. I believe that's the one that's.
And then there's the 3786.
Judge, the 1961 is the one where they were friends. They were hanging out. I believe the victim went to go get a drink and went into a bedroom with another individual, and he barged in through the door and hit her with a hacksaw.
A 12-inch Stanley hacksaw, Your Honor.
Judge, these are the allegations, and I believe there's a proper forum to argue those. However, Judge, I do believe that that the CW in that case specifically is also one that I feel is not going to be available.
And Your Honor, with all due respect, Mr. Kanata, you got to talk about how you think that these two are going to, you know, they're great for the defense. Well, then
I didn't go
let's
into the
talk about
facts.
how I
the
think,
facts.
based on the facts, I'm talking about the police reports, how I think that these are great for the state, Judge. And if we're just going to be going off arguments, then the state can make an argument as well at this bond hearing.
Nobody brought up the facts.
What's good for the goose is good for the gander. As far as I'm concerned, the rules of evidence apply to both sides equally. But Your Honor, if we would just set these for a trial and get the jury out here, then we either have a victim or we don't. And either Mr. Kanata, you know, walks the defendant or he doesn't.
Ms. Vergara, that's why I have the utmost respect for you. I think she hit it on the dot.
Let's see, I think we're running past time that we have in the jail for our jail hearing, but I do want to, I'll think about it a little bit more, but you know, I do think there's a lot of the defendant does not have a good record in particular, and there's a lot of alleged violence here, which concerns me. And so, you know, I really doubt that I'm going to reduce the bonds in amount, if at all. But I do want to have another hearing, maybe just next week, next Tuesday. We could have a little more time. I don't want it to be rushed. I want you both to be able to express your full concerns about your case to me, and because we're getting a little rushed on it, and I don't want that to happen. I never like to rush to judgment. I like to be able to contemplate everything. I do have a lot of notes on these cases that between the state and you, Mr. Kinata, have given to me. Some of them very favorable to the state, some of them favorable to the defense, and I'd like to get a better chance to review those. I think I should have that opportunity by next Tuesday, so we can reconvene that on Tuesday. I look forward to seeing you all. All have a good weekend, and we'll see you.
Likewise, Judge. Thank you, Your Honor. I want to thank the state, Ms. Vergara, Ms. Ritchie, and I want to thank Bobby and Michelle for making this happen, Araceli. Thank you, guys. Your Honor, you have a beautiful weekend as well. Mr. Torres will be in touch.
Sure.
And we obviously, Judge, in the interim, we would like to see if we can get on that jury trial fast track, Judge. If possible.
He will be on the faster track because he has in excess of 1 year, and those will be the ones that'll go first. And I mean, he's not the first one. I mean, he hasn't been in jail the longest of every one of my defendants, but he's probably in the top 10 or so. So he's not way down at the bottom of the list or anything.
We're optimistic, Your Honor. We're optimistic, and maybe in the interim, we might be able to come down to some type of resolution for all the cases. That would be fantastic. I do know his mom was waiting for him, and I do know that I'd like to assist everybody in taking all these cases off the plate. I do know Mr. Torres wants resolution as well. So thank you, Judge. You guys have a beautiful weekend. I don't want to take up too much more time. Thank you, Judge. May I be excused.
All right. Well,
Hey,
thank
Mr.
you.
Canada.
Thank you and all from the jail and the annex. And
Yes, sir. Thank you.
all right. And
Ms. Vergara, what is your first name?
Linsui, Linzui. And then my last name is V as in Victor, ERGARA.
Thank you.
Thank you, ma'am.
all right. Thank you all.